Good morning for my online classes for my full semester and second 8 weeks class. I'm Jeff Birdsong, greet you here on a bright sunny January morning, January the 28th, recording Chapter 4, Civil Liberties. So I would assume in the next week or so my full semester class will be reviewing this lecture, and later on in late March I'll have the second 8 week students reviewing this lecture. Chapter 4, Civil Liberties. Are you aware of your individual rights? This is very important, and it should come as no surprise that in many cases people aren't aware of those rights. And this is why we can see the need to have that reminded of people when they're being questioned by the police, when they're being investigated. What rights do they have? Knowledge is power. So in particular, as we'll cover here today, we'll look at these rights of the individual, especially the First, Fourth, Fifth, and Sixth and Eighth Amendments of the Constitution. I've had students in the past watch this movie. I've suggested this for the last couple of years in my online class and also in my face-to-face class. It's an eye-opening experience for many people who watch this movie. This was a controversial movie when it was made. There were people who were reviewing this movie that were actually so offended by it that they got up and walked out. So I would just suggest perhaps reading some reviews of the movie, or watching clips of the movie, or watching the whole movie. Now, what is interesting about this, and the fact that people were offended, is that this movie is based on real events. And I'm always reminded of this movie when I think of what do people know about their individual rights. If they are suspected of committing a crime, what rights do they at that point have? And in this movie, a young woman who's working at a fast food restaurant has been accused of being a thief. What rights does she at that point have? And so this is based on the real events of Louise Ogburn, and a young woman who was working at a fast food restaurant, and the situation that she was put through. Absolutely, you can review this whole event and say, what was going on with Miss Ogburn? Didn't she realize that she didn't have to put herself through this situation? Well, perhaps she should have been able to think through that. But she didn't, and there is, again, this importance of being reminded you have certain rights. You don't have to go through this kind of situation. And so, in many cases, though, our interpretation of these rights will come through court cases. What does freedom of speech mean? What does freedom of association mean? Freedom of religion. And so it's the interpretation of those comes from historical events and interpretations of court cases. So in Schenck versus United States in 1919, the conclusion was on the Supreme Court that there's a difference between peacetime and wartime speech. And the socialists at this time had printed up to 15,000 anti-draft leaflets. And there was then this belief that what they were doing to try to get young men to not participate in the draft for World War I, that this was a violation of the Espionage Act, a crime to make false reports with the intent to interfere with military operations. Interesting, the socialists based their whole activity on another amendment to the Constitution, and that was the 13th Amendment, the amendment that abolished slavery. Their view was that a draft was a form of slavery, that people are now drafted, forced to serve into the military, with few exceptions, and so that, in their view, was not constitutional based on the 13th Amendment. So here we can see this conflict. I think we can quickly surmise the idea that the Constitution puts everything to rest just isn't the case. Here you have one view that this is a violation of the First Amendment, and then you have another belief that this is a violation of the 13th Amendment. And here you have then the courts that have to make this decision, the Supreme Court. Supreme Court rules against the socialist. And Oliver Wendell Holmes, the Supreme Court Justice writing for the majority, states that the words used are in such circumstances and are of such a nature as to create a clear and present danger. So certainly read about this, the clear and present danger test, on page 126 in your text. Now, interesting here, and this is the ongoing challenge for us, challenging the government, challenging the legality of a draft, trying to compel young people to not participate in the draft. Is that a clear and present danger? Well, if the courts say that it is, it tends to be the outcome, and that was the situation there. So in other words, can free speech be absolute? In most circumstances, there may be some cases in which you go, maybe that doesn't exactly apply. Can you say what you want when you want to? Clear and present danger tests suggest not so much. So we can think of some other situations here. A current issue facing a man named Bradley Manning, who is actually in the process of going into the female gender, and but he has been sentenced to 35 years of age, 35 years in prison, excuse me, and the issue was he a spy or was he exposing a war crime? Is this a First Amendment right, or was he a violation of his role of as a soldier? Worth looking into. Spend some time reading about the life of this person and his sentence as well. So what is the correct way of looking at freedom of speech? And Bradley Manning is a very good example of that. So we have nonverbal speech, and again, raising that question of how can you express yourself? Is it absolute, or are there times in which that expression can be limited? So read about symbolic speech on page 130, which is nonverbal speech often used in protest. And certainly one of the better examples of that would be flag burning. Nonverbal speech, symbolic speech. It is an offensive act, I think, viewed by most people, but do people have a right to be offensive? Do you have to tolerate being offended in a free society? And so in this case, these individuals certainly don't have a right to destroy other people's property, but if it is their property, if they're in a situation where burning is allowed, are they able to express themselves? And in most instances, the courts are going to say, yes, that symbolic speech, offensive speech, is protected. Another form of speech that is questioned on whether or not it's protected would be pornography, what is considered obscene. And the test here would be on page 133, and you'll see these same standards for what's called the Miller test. And the Miller test is to determine whether or not something is obscene. If it's obscene, you could say the courts can make the conclusion it's not allowed to be distributed. But these are the standards that have to be followed. You have to have a jury that makes that decision that it is in fact obscene. Work deemed prurient, impure in thought by the average person according to community standards. Depicts sexual conduct in a patently offensive way. Lacks serious literary, artistic, political, or scientific value. It's fairly broad, but at the same time, it's hard to then pinpoint how you could exactly say that would be something that would be considered obscene. But you can also then conclude that if you're able to get a jury to agree, then is that enough of a standard to say so? This is where we're going through, when you look at issues like symbolic speech, clear and present danger test, obscenity, you're faced then with this issue of what's referred to as the balancing doctrine. And picture a scale. So on one side you have the rights of the individuals to be able to express yourself in a way, a person has the right to express himself or herself in a way that is offensive to many other people. We may view it that way, that is correct, but there is also, is there not a need, going back to our very first time together and we think about the original dilemma, freedom versus order. So here you have this question of the need to protect society. Government is in place to protect society. So you can express yourself, but what if in the process of somebody expressing himself, it's actually causing harm to society? So there's the need for the balancing doctrine. Again, the role of the courts in its interpretation of the Constitution. That speech, the very first freedom that's brought out in the First Amendment is freedom of religion. And so spend some time reading through pages 122, 123 on the Establishment Clause, and then 124, 125 on the Free Exercise Clause. These are the two clauses of religion that are brought out in the First Amendment. And here you see the rights of the criminally accused on pages 137 to 144. You see here search and seizure, grand jury, the rights to a grand jury, double jeopardy, self-incrimination, eminent domain. That's what you find in the Fifth Amendment. The Sixth Amendment, the right to counsel. The Eighth Amendment, cruel and unusual punishment. So let's go into some detail here about these amendments. In search and seizure, you have the Fourth Amendment, protects individuals and their properties from unreasonable search and seizure. The Fifth Amendment determines whether there is sufficient evidence to bring the accused to trial. Double jeopardy, no retrial for the same offense. Offers no protection when conduct violates both federal and state law. So let's unpack a few of these things that we're covering here. So we'll come back to the Fifth Amendment. The Fourth Amendment protects individuals and their properties from unreasonable search and seizure. How do you exactly determine what is a reasonable search and seizure? You can come into different ways of looking at that based on whether there was a search warrant. Clearly is one of the issues. Is it reasonable to be able to search a car in a different amount of requirements than searching someone's home? And the courts have consistently said, yeah, there's differences there. And certainly none of this applies if you have police invited into a home and they ask to search, or that the police are in hot pursuit, or the police believe someone's being harmed inside the house. Then so there are ways in which that's all viewed to be reasonable, that the police got into the house without a search warrant. And so the grand jury is oftentimes viewed as a jury that they're there to just find, as you can see, their evidence. So they're not to determine innocence or guilt, and they're to indict. And so is there a case in which a defendant has the right to a grand jury? Here we can see that's part of the Fifth Amendment right. And so a defendant may want that because there's a case of saying, we're going to go ahead and make this determination, that it's one more hoop perhaps that the state has to jump through to make a determination that someone is, there's sufficient evidence to go to trial. Of course, you could actually have a defendant that says, I don't want a grand jury, right? I'd rather go directly to trial because I don't believe there's enough evidence to actually convict the defendant. So there's different ways of using the grand jury, but it should be in some ways a level of protection there for the defendant. And certainly the same thing for double jeopardy. But do notice here that there's protection. There is no protection if this is federal or violates both federal and state law. So in other words, if someone's found not guilty at the state level, there could still then be a trial based on some of the same evidence that occur of the crime at the federal level. So you could have police officers, let's say, that are found not guilty of police brutality at the state level, could still then be charged for violation of a person's civil rights at the federal level. Something like that could occur. Probably what's best known about the Fifth Amendment: cannot be compelled to be a witness against yourself, so the right to remain silent. Another part that's not really brought out that much about the Fifth Amendment: full value of property taken for public use must be paid to the owner. So there is not this situation in which somebody has that the state can just, if they're wanting to widen a highway, let's widen the highway, so go from a 2-lane to a 4-lane highway. You can't have a case in which, in the process of widening that highway, they now take over someone else's property and not pay for it. So now, that may mean that somebody who has this property and doesn't want to sell will be compelled to sell because it's in the best interest of the state. But at least they are going to be compensated for it. It's not just in the case in which the property is taken. The right to counsel. Defendants have the right to an attorney here in the Sixth Amendment. What if the defendant cannot afford an attorney? So notice, if you read through the Sixth Amendment, there's nothing stating what happens if an individual cannot afford an attorney. So for many years, that interpretation just simply meant you had the right to an attorney if you could afford one. If you could not, you didn't get an attorney. But in this case, involving Clarence Gideon, the case is known as Gideon v. Wainwright, which you'll certainly see in your text, that Mr. Gideon was found guilty of burglary, and he's in the Florida penitentiary. He appeals to a higher court, and this occurred back in the 1960s. He wrote out his own appeal first, called the Writ of Pauperis, and he asked the courts to look into this situation. The Supreme Court heard the case, decided to hear the case, and reviewed the case. He got an attorney, he was retried, and he was found not guilty. It's a fascinating story. It's one of the most American stories, really, in a way, when you think about what happened here with Mr. Gideon. This guy had an 8th grade education. He had been in and out of jail most of his life. And he had done a lot of dumb things and bad things. But he didn't do this. And he was wrongly convicted. And he reviews the situation, writes his own appeal, contacts courts in the appeal process, gets his attorney and retried. And it now is the conclusion that there's not the possibility of a fair trial without an individual having the right to an attorney. A very important case, Gideon v. Wainwright. We also now know about the protections from self-incrimination. It comes from Miranda rights, Miranda v. Arizona. You'll certainly see that in your text. Clarence Gideon, I just mentioned, was a guy who was a ne'er-do-well, and he created some problems in terms of robbery and what have you. And that's bad, but he wasn't really a mean person to other people. But Miranda, we're looking, Ernesto Miranda is a bad person. This is an individual who would kidnap women, rape them. And yet, even there, we're still left with that question: do people have the right to know about to be informed of their rights when they're being questioned by the police, even someone who, by all accounts, is just a very bad person? And that's the conclusion that, yes, there are basic rights people need to know. So, Miranda rights, again, reading your text, Miranda v. Arizona, the right to remain silent. The warning: what you say will be used against you or can be used against you. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you. So we can see the Fifth Amendment's brought out in the Miranda rights, as is also the Sixth Amendment, the right to an attorney. Now, one of the interesting issues here about the Miranda rights is once somebody has been read those rights, the right to remain silent, first off, they need to say they will choose to remain silent. So it's not enough to interpret just simply by remaining silent that you're remaining silent. That sounds rather odd, but that's the situation. And a recent interpretation with Miranda deals with how long after the police have questioned someone and they've decided to remain silent and they're not going to say anything, can the police again go and question that person? And if you'll notice here, this is a case by the court in February 2010, Maryland v. Schatzter, that there's a 14-day window, there's a gap, that so once the police have gone through this, that someone has chosen to remain silent, and then the police have to wait 2 weeks and then they can go back at them again. Now, I think what's interesting about that is that, I mean, it's rather arbitrary to come up with the 2-week period, but you can imagine the inadequacy of Miranda if the police would say, okay, fine, we're going to ask you that. You say you're going to remain silent. You're not going to answer anything. Well, we'll see you tomorrow. We'll do the same thing tomorrow, all right? And the day after that, and the day after that. How adequate really is the Miranda rights at that point, right? So there's, in some ways, a 2-week period here after that's been used. The exclusionary rule, looking at the Fourth Amendment, and so as you read through this text, make notes of these key court cases and how they are attached to a particular amendment. So in this case, Mapp v. Ohio. And Dahl re Mapp was involved in a situation where they found in her home pornographic material, and it was in a trunk in the basement. This was not on the search warrant to look for this material. There it was, and they wanted to introduce this into the courts. Now, her attorneys actually thought this would be a First Amendment issue on freedom of expression, freedom of speech, freedom of the press. But what it turned out to be was an issue on the Fourth Amendment. Was this a reasonable search? Was it on a search warrant? What do you do with the evidence if it's gathered in an unreasonable way? And this is where the exclusionary rule comes in to say that people, the evidence will not be admitted into court. This then leads to an interesting issue for us as a society. So this was a crossover discussion among two of the justices when they were talking about Mapp v. Ohio and throwing evidence out that's gathered in an unreasonable search. So Justice Cardozo says the criminal is to go free because the constable has blundered. And Clark, another justice, says the criminal goes free if he must, but it is the law that sets him free. So this is one of those issues to say, is the law superior to any particular act? And you may have heard this phrase before, it's better to have 99 guilty people walking the streets than one innocent person in prison. Well, that's all well and good, but if the police have now gathered evidence and it was deemed to be unreasonable, based on the process of a search warrant, and the person goes free. It might be one thing to let the person go free that has possession of pornographic material or possession of drugs, but what if you're letting someone go free because they had 3 dead bodies in their basement? What about the severity of the crime? And of course, that's one of the big debates that goes on in the Fourth Amendment, that coming back to the issue of what is reasonable. It would not be reasonable to let someone go if their crime is so severe, if just simply because the evidence was gathered in a way that didn't exactly fit the boundaries of a search warrant. The Fourth Amendment is in many ways all over the place. Moving on to the Eighth Amendment, protection from cruel and unusual punishment is one of the key ways in which we see that the Eighth Amendment is brought out. And that's what's probably discussed about this amendment more than anything else. So when you look at this, you're discussing clearly, again, the death penalty. And the death penalty is ongoing in our society to say, is it cruel and unusual? Is any form of the death penalty cruel and unusual? It is, from a historical sense, worth repeating or reminding ourselves that any time there's been a new method of execution, like we see here now in this picture, the use of the electric chair, that it's almost always been viewed when you've introduced a new method that it's humane. So the electric chair, when it was introduced, was to be humane. And then we've now had considerable discussions and that maybe the electric chair doesn't fit that parameter anymore at all. And most states no longer use the electric chair. And there's been some real questions about its efficiency and certainly what happens to a person who is executed this way. And can we say, without a doubt, that people who are convicted of any crime, but perhaps most importantly, crimes that would warrant the death penalty, were they in fact guilty of that crime? And so, again, do some outside research. I would urge you to do that. Hopefully you find this class worthwhile to spend some time beyond just the text or my lectures to look into this material. Go online and check a website called the Innocence Project. There you will find that there have been many people wrongfully convicted, and some of those on death row that have been then released. And one gentleman was Greg Wilhoit, who passed away a couple of years ago. But Greg Wilhoit in the state of Oklahoma was on death row for many years, days away from being executed on a few occasions. And unfortunately was not able to live much of his life in freedom after he was released. He died not too long afterwards. But his experience is also worth checking out online about what it means to be on death row. And do we in fact have people on death row that are innocent? He was found to be innocent later on. So it's an interesting challenge to us, going back to one of our framers of this country, Ben Franklin, and saying that he has, those who sacrifice liberty for security deserve neither. So if we're in this process of trying to come up with a better, safer society, and we give up our freedom in the point, our freedom of expression, our protections against unreasonable intrusions by law enforcement and the legal system, we're not going to be free, and we're not going to be safer, according to Ben. Worth considering. So at the end of this book, you'll see, at the end of this chapter, you see here the Patriot Act, pages 149, 150. This certainly came into place not too long after 9/11. So for many of you taking this class, you've grown up with the use of the Patriot Act. Well, June 1st of this year, so as I was teaching this class in the summer, this came out to see some of the changes that have occurred with the Patriot Act. But notice our ongoing conflict or debate about the role of government, and again, the original dilemma, freedom versus order. So the National Security Agency, a very powerful bureaucratic agency, cannot collect metadata, just this huge amount of data on phone calls or email messages without getting the proper notification warrants, for example. And the same thing can be said on a roving wiretap, must get individual warrants. Who exactly are you wanting to listen to? And then 3, cannot use national security tools against a lone wolf unless suspect is connected to a known foreign terrorist organization. Think about that last phrase there, known foreign terrorist organization. And consider what happened just a few months ago in San Bernardino, California, where you had a husband and wife go into community center and shoot up and kill many people there. Were they not worthy of being investigated because they weren't connected to a foreign terrorist organization? So there we can see that this issue is not put to rest. So there was a belief in our Congress that the Patriot Act had gone too far and it was punishing innocent people. And so they rolled back some of the Patriot Act. Now, we've had a terrorist attack, and there's going to be some genuine questions on the role of the government in trying to create more security. But think again of Ben Franklin's quote there. Is it still relevant? Is it still something that we need to consider? Right to privacy, the last part here that we'll cover, and I will touch base a little bit more on freedom of religion. Didn't go into detail on that as much as I should have. But the right to privacy, read about that on pages 144 to 149. Key part of this is the case Griswold v. Connecticut in 1965, and a key part of that case deals with the right to birth control. And you're looking here at 4 amendments that were used on the issue of the right to birth control, the right to, which would then be under the umbrella right of the right to privacy. But the Third Amendment, spend some time reading over these amendments, but the protection against housing soldiers on your property during peacetime, that's the Third Amendment. That certainly suggests a right to privacy. The Fourth Amendment, protection again, as we've discussed, unreasonable search and seizure, another right to privacy. The Fifth Amendment, protection against self-incrimination. You do not need to say anything if you do not want to during an investigation. Suggests a right to privacy. And the Ninth Amendment, protections against people against other intrusions by the government, rights retained by the people in other instances. Kind of a broad scope of this amendment that suggests that there are rights that people enjoy that do not have to specifically be written down in the Constitution. So could one of those rights that people enjoy be the right to privacy? And it's been suggested that's one of those rights. So, for example, think about the Ninth Amendment, other unwritten rights. Do we have to write down every right that people are to enjoy? And that's why the importance of the Ninth Amendment. So in other words, we don't have an amendment that says that people have the right to teach a child, their child, a foreign language. But does there need to be a separate amendment that says that? That's what the Ninth Amendment's for. We don't have an amendment that says people have the right to send their children to private schools. But that's what the Ninth Amendment's for. The right to procreate, that's what the Ninth Amendment's for. That's very important in a way, very challenging. Do people who have a certain IQ level still have the right to reproduce? Where's the role of the state to be able to interfere and say you don't have that right? And so this is a conclusion that's been, and there was an attempt in the United States, but not an attempt, it happened for a good period of years that there was mandatory sterilization among people that was perceived to be that they were a danger to themselves or others, with some fairly flimsy psychological testing going on. And so that challenge has been brought out to say, no, the Ninth Amendment protects people's right to procreate, the right to travel abroad. So again, looking at this issue, you don't have to have a separate amendment for this, just simply state that's protected under the Ninth Amendment, rights retained by the people. So the Ninth Amendment clearly is brought out in our attention today, and read about this in your text on issues such as abortion and homosexuality. Are these rights, privacy rights that are given to people in this case? The right to privacy to terminate a pregnancy, the right to privacy to engage in a sexual behavior that for many states had listed this as illegal, but then the question is to say, in the privacy of one's home, do you have that right? And if you have that right to engage in that behavior, does that behavior then extend to other rights that we've seen discussed already in this class when we look at Chapter 3 on federalism and looking at marriage as a contract? So spend some time certainly reading about this debate under these two activities and the right to privacy. So clearly one of the big issues here is on pages 118 to 121, dealing with the nationalization of the Bill of Rights. And this all comes back then to the 14th Amendment, equal protection under the law. So certainly focus on that, and how then you get freedom of speech to apply the same in all the states. So our idea here is to say, how adequate would freedom of speech be if you had a certain type of freedom of speech in Oregon, but you don't have it in Oklahoma? So we've discussed federalism. That was Chapter 3. We can see, I think, some benefits of having differences among the states. But the interpretation of the Bill of Rights, should that be one of those areas in which you have different interpretations? There can still be some segments of the Bill of Rights where there are, in fact, separate interpretations. In other words, that some of those areas have not been incorporated. but most of them now have been incorporated into the 14th Amendment. Equal protection under the law, meaning equal protection in Oklahoma, equal protection in Maine, equal protection in Florida, in the interpretation of freedom of religion, the interpretation of the Fourth Amendment, for example. So again, 118 to 121, certainly read over that. Let me go back here, and I know you'll see a little bit of a flashback as we do this, but I apologize for not going into a lot of detail right at first dealing with freedom of religion. So let me just discuss a little bit here before we close Chapter 4 on these two clauses that you'll see when you read through the First Amendment in the Constitution. The Establishment Clause, pages 122, 123. Look at some of the court cases that are dealt with on Establishment Clause. The state cannot establish an official religion. That's the main way in which we see this interpreted. Now, does an individual state have a right to establish an official religion? That's a little bit up in the air. We don't have any state that does have an official religion or an official church. But notice there, I mean, an official religion. So it would be one thing to say, well, okay, the Baptist Church is the official church. We don't have that, but nor do we even have an official religion. We can't say that Christianity is the official religion of the United States. There's nothing stipulating that. And in fact, the Establishment Clause would say you can't do that in the United States. Are you promoting one religion over another if you have prayer in school? And it depends on who's leading the prayer and the circumstances. Are you promoting one religion over another if you have the state providing financial assistance to a school? Again, depends on what the financial assistance is for, the circumstances. And so you'll see that when you look at issues such as the Lemon Test, for example, that's brought out there. And so certainly look at those issues on these pages. The Free Exercise Clause would look at the issue of, are there limits to religious expression? And in most instances, there are not. So religious expression can go the route of even having cults involved, a religious cult. Someone can join a religious cult, which might mean if the person's over 18 and our view of this cult, you have one particular person who's viewed as a guru, and which there's almost all devotion to that one individual. You have people giving most of their financial rewards or savings or benefits to that individual or to that church or that organization. People are subjecting themselves to tremendous psychological or physical pressures. That's generally how we view some of the standards to say that someone is a member of a cult. However, in the United States, if the person's over 18, that's viewed constitutional, that people have the right to do that. It's part of the Free Exercise Clause. They have the right to join an organization like that. So this is where we really see the great benefits of freedom of religion, and you'll see some court cases in these pages that look at those issues. So certainly focus on that in that area, a very important part of our country and our freedom of religion. Again, with freedom of religion, people may join organizations that many of us may find to be offensive. And with freedom of speech, people may express themselves in ways that many of us may find offensive. And there's the challenge. Does freedom mean that the rest of us in certain times will be offended? That ongoing challenge of freedom versus order. We'll leave it at that. That's Chapter 4, looking at civil liberties. We'll be turning our attention to civil rights, Chapter 5, in our next recorded lecture.